Morning.
Good morning, Your Honor.
Good morning.
Good morning, Your Honor.
Okay, so I have this morning on for a continuation of a TRO or something. We're going to figure out what exactly it is today and the status of the case in the Me and My Company LLC versus Asia Rooks et al. My understanding is that Um, obviously, I previously entered a TRO. It was ex parte. I think I noted in the order that it was not intended to be ex parte, but that despite some evidence of notice to the parties, the defendants did not appear at the hearing. My understanding since then, based on a review of the record, is that the Wilson defendants have been served and appeared in the case, filed an answer, and that there's an order for service by publication for Ms. Rooks that is not yet ripe for an answer, and that there is an acknowledgement of service on Naomi Organics to the Secretary of State, which is also not yet ripe for an answer. Is that the correct procedural posture of the case, Mr. Hendrick?
Yes, Your Honor.
Okay. Ms. Parks, are you here on behalf of the Wilson defendants?
And Your Honor, yesterday around lunchtime, we came to a consent preliminary injunction order to extend through the 31st so that my client and the plaintiffs can have a chance to try to resolve all of their issues. I just wanted to appear this morning just to make sure that that portion for him was ironed out.
I appreciate that very much. And I did see, and I should have noted that as part of my procedural history, I did see that y'all had worked out a consent TRO. And then beyond that, Mr. Hendrick, I think my staff attorney indicated that in terms of figuring out if parties were going to appear today, that he mentioned to you, or excuse me, that you had advised the court through my staff attorney that you had had some initial contact with Ms. Rooks and thought that she might appear today. Is that correct?
Yes, Your Honor. I don't know who Girl Boss Hotline is, but that might be Ms. Rooks. And yesterday I provided Ms. Rooks with a copy of the notice of today's hearing
Okay.
that had the Zoom link on it. And she emailed me back and said, acknowledged that she had received it. So she has received notice of today's hearing.
Okay, excellent. So Girl Boss Hotline, you're in my Zoom. Are you wishing to participate in the proceeding?
Yes, ma'am. This was the only email I had. I'm Asia Rooks.
Okay. Ms. Rooks, are you able to turn your video on, ma'am?
Sure.
Thank you so much. So Ms. Rooks, just so you understand the purpose of today's hearing, we actually had a hearing about a month ago where the court entered a temporary restraining order restraining certain actions that had been alleged by the plaintiff in the case, were being actions that were being taken by the defendants that were interfering. And so the court entered a TRO. But the purpose of today's hearing was to revisit that TRO to determine if it should continue, and what are and to give an opportunity since the last hearing was conducted with defendants absent, albeit they notice was given. So there are a couple of things I want to make sure you're aware of, and then I have a couple of questions for you. Number one, do you have an attorney, Ms. Rooks?
Not as of yet, no.
Okay. So I want to tell you, Ms. Rooks, that I can't give you legal advice, but I do want to make sure you understand that you can represent yourself in a case like this. You shouldn't. That's a bad idea. I don't suggest it. You can, but I do want to make sure that you understand that your company, Naomi Organics, by law, it cannot represent itself. You cannot represent it in this proceeding. It must have a lawyer or it will not be represented. Do you understand that, Ms. Rooks?
Yes.
Okay. The other thing is that the purpose of today's hearing, and I'm going to in a moment sort of hand it over to Mr. Hendrick, is to determine, since the Wilson defendants have worked out the scope of the TRO for them, was to hear from Mr. Hendrick to determine whether and to what extent the TRO needs to be continued for some period of time, relative to Ms. Rooks and Naomi Organics. Mr. Hendrick?
Yes, Your Honor. Thank you very much. And to give you just a little bit of background, I guess, on what's occurred in the last 24 hours.
Yes, sir.
So I did have several conversations with Ms. Parks, and they were very helpful conversations. I explained to her the concerns that my client had, and she was very transparent, I felt like, as far as what her client was still doing in the space and their concerns with the TRO that had been entered. And that's why, if you notice, the TRO, or excuse me, the consent preliminary injunction that we entered yesterday was incredibly similar to the TRO that the court initially entered. There was one paragraph that was deleted, and that was the paragraph that said that it was the paragraph that said that Mr. Wilson and his company could not basically work in that space at all. Work with any company that sold any sort of products that were competing in any sort of way.
Right.
And during my conversation yesterday with Ms. Parks, she explained to me that her client was working with one company that operated in that space, that company did have some products that competed with me and that those products had pre-existed Mr. Wilson's engagement with me and
And hopefully we're not being marketed in a way that was remarkably similar to the ones that were being marketed by me and my.
Yes, Your Honor. I asked Ms. Parks if she would not mind at least sharing with me, and I told her, and my client can vouch that I have not disclosed it to her. I said, I understand customer lists and who your customers are, those are trade secret under Georgia law in many instances. I said, but if you would share that with me, let me go look at that website and I will relay to my client my thoughts on it. And Ms. Parks did that. And I went and looked at this website, and they do have some competing products, but the sorts of similarities that we were seeing in the evidence that we provided with the court were not there. It wasn't the same color scheme. It wasn't the same packaging. It wasn't the same slogans. It was the entire setup was just different. And so based on that and Ms. Park's representation, I advised my client, and we agreed to remove that one paragraph that had been in the initial TRO. And that is what gave me and my client comfort in removing that paragraph in the consent preliminary injunction that we provided to the court.
Okay.
My client also had an initial conversation with Ms. Rooks, and both of them expressed a willingness and desire to work this out without having to go through an entire litigation, discovery, trial. And so I spoke with Ms. Rooks yesterday, and I think that one of the problems there is that and I'm trying to be as polite as I can when I is phrasing this. I don't think she realized that what she's doing is illegal, that it breaks trade dress laws. She did acknowledge to my client and to me that she had connections with at least some of the websites and some of the companies that we had identified. And if the court will indulge me a second, I can share. So yesterday, I took a screenshot, and can the court see this?
Yes, I can.
So this is the Divine Kitty website. I took this screenshot yesterday at 3:21 p.m. And this is one of the trade dress infringement issues that we had identified. This is remarkably similar.
Right, I remember the product. Yeah.
Yep. And so, and even down to the Bayer bottle that it's being marketed in, and that was ongoing as of yesterday afternoon. Now, after that conversation, Ms. Rook said that she would change the Bayer design, and within, I think, an hour, If you looked at Divine Kitty's website right now, they still have that product. It looks like it's like a little syrup bottle, like pancake syrup bottle, but not the bear bottle. But
So it went from being in a honey container into a pancake syrup container, but
yeah, that's what it
anyway.
looked like. But one of the problems we have is just honestly the concern, and why we were hesitant to enter into the same sort of order is part of it is because we just don't think she realizes what she's doing violates certain laws, and we're concerned that she will continue to do so if she's permitted to work in the space. During my conversation with her yesterday, one of the comments she made was, I mean, anybody can do this. All you need is Chat GPT. You can take somebody's ad, you plug it into Chat GPT, and they'll make you a very similar ad immediately. And, in this space, I think this is one of the problems that companies like Miss Pettigrew and the courts and attorneys are going to have to confront, is that you no longer have to go to Madison Avenue and, get some madmen and they're going to draw up a sketch. It's so easy to just rip off other companies, and the feel, the design of these ads, the websites. And that is my client's frustration, is that her company and everything that she has tried to do to separate herself in this market, and that she's been very successful doing over the years, is just being ripped off and stolen. Even the website that I just showed you, down to the way that the products are, each of them's on like a small block in the way that they're done. When you go to another website that's not just such a ripoff, for example, the one that I went to yesterday, all of their ads and their marketing they look different. And we talked about that during the last hearing when you're talking about trade dress, that it's one of those things that so much of it is you look at it and you go, that's really similar. And when you start adding all of these things up, and this has just been a consistent long-running problem that my client has had with respect to products that Ms. Rooks has marketed and companies that she's been involved with. And one of the concerns I have is the marketing, the picture on the website changed yesterday. But when I was talking to her, she told me that her client, she says that she doesn't own this website. This is her marketing company. I guess she now has a marketing company, and this is one of her clients, and she's helping them with their marketing slogans, designs, and that he had already ordered a substantial number of these bear bottles. And so that he would at least have to go through and use all of them. And the problem is, every single time he sends one of those bear bottles out into commerce, regardless of what the ad looks like on the website, that is going to lead to a likelihood of confusion and to dilution, because you're going to have consumers out there and they may be out. You can see exactly how it work. You're out having dinner or drinks with a friend, and you tell them, oh, I've got this great new product. I can't remember where I got it. It's in a little bear bottle, and it's really cute. And and if they just say Divine Kitty and then they go and they find it, and if this is the problem that can persist as far as confusion, brand dilution, and trade dress infringement. So we do still have concerns as far as Ms. Rooks is concerned. I can tell you that my client still does want to work this out. And, the most important thing for her is just that all of this stops. More so, last time during our hearing, I informed the court, represented to the court, that my client's company saw their sales drop by between 30 and 40%. Jasmine, you can just nod. Was it as high as 40% that you saw your sales drop? I seem to recall that was the figure you told me.
It was 30.
30%. So she saw her sales drop by as much as 30%, which is a significant drop in her revenue. When all of these, I call it whack-a-mole websites, started popping up. And so that really has been a concern. And that's more than anything, she just wants it to stop. She wants to be able to continue to come up with the sorts of marketing slogans and strategies and come up with these unique trade dress facets of her website that have helped her to be successful and not have to worry about Ms. Rooks coming onto her website and within hours having something else out there that looks and feels exactly like the ad that she just came up with, or the ad that she's had for years that's been successful. And so that's where we are. And, as I said in my conversations with Ms. Rooks, and the conversation she had with my client, she acknowledged and admitted that she was connected with at least some of these websites, and we have doubts if it was just some. And she continues to be connected with Divine Kitty, and so we're concerned that the problems with respect to Ms. Rooks are going to persist without an injunction, and so we would ask that the court extend the injunction that it currently entered for the pendency of this lawsuit, with the understanding that, after this lawsuit, we intend to continue to pursue resolution. That's what we want. So thank you, Your Honor.
Thank you, Mr. Hendrick. Ms. Rooks, as I mentioned, you are allowed to represent yourself in for purposes of today. But the purpose of today's hearing was to discuss whether or not the court should continue the temporary restraining order that is already in effect. Did you wish to respond in any way to what Mr. Hendrick said on your own behalf, Ms. Rooks?
Yes, one moment, let me just start the video. Okay, so what I would like to request is, because I was just recently served, like I was just able to get the paperwork and be served and like read through it. So I would like the opportunity to be able to seek counsel as well, and get an attorney and hopefully like revisit this is what I was hoping for, just because yesterday we had come to, when Jasmine and I spoke, it was a conversation of if I remove the bear from our client, that we would be okay. And that was our biggest thing. And then of course, if ads don't look similar, which me personally, I don't think the website looks like me and mine. I did design the website, but I didn't design it with her website in mind at all. And I've been in the feminine hygiene space since 2019. So it's a little, it just feels very restrictive for me not to be able to work in feminine hygiene at all, because that's, at this point, my only means of income and livelihood. So I would be not able to take care of myself and provide for myself if so. So I was hoping that I could come to a conclusion where, like, whatever she has an issue with, I would stop it immediately. I was very transparent and honest about the companies that I currently have involvement with. Naomi Organics is dissolved and not operating anymore. So I was just hoping that we could come to a conclusion on the only company that I currently have an involvement with, which is Divine Kitty. And so I changed I am a graphic designer as well, so I did change the bear, but then I signed an agreement as well saying that I would have the same type of agreement as, I forgot the other guy's name, but we came to
Mr. Wilson.
Yeah, Mr. Wilson. And then she changed her mind about that after, I'm not sure for whatever reason, after I'd already signed the agreement. So now I would like to, get an attorney as well to try to protect myself, but it just feels very like restrictive. I'm not stalking or harassing or doing anything. Like, I understand the trade dress issue. So that's why I'm more than willing to be compliant in that way. But to say like, you don't want me to sell anything in this space that I've been in for years feels just unfair and kind of a little bit like I'm being bullied. So yeah, I'm just requesting, the opportunity to be able to seek counsel, which I started on, and I was just told to be asked for continuance and to be able to reschedule the hearing, pretty much, since I was just informed of this lawsuit.
Okay. Thank you, Ms. Rooks.
Thank you.
So a couple things that are to me outcome determinative here. One, I think Mr. Hendrick and Ms. Parks have set an excellent example of figuring out what is the real issue that they're concerned about and making sure that any restraining order that the court enters is not overly restrictive, right? Because it's not the court's intention, nor sounds from Mr. Hendrick, is it his intention to unfairly restrain competition, which of course we don't want to do. It sounds as if Ms. Rooks is expressing the same concern that Ms. Parks expressed on behalf of her client regarding her ability to function in that general commerce space, and that ultimately, if Ms. Rooks were competing in that general space in a way that did not implicate copying, of trade dress and other marketing signals that belong to and are utilized by Ms. Nicole's company, that Ms. Ms. Nicole would be satisfied with that. And it also sounds like there have been some positive conversations. So Ms. Rooks, the main thing for you to understand is, while I definitely want you to get an attorney, and I think that you having an attorney, and it sounds like from Mr. Hendrick's point that you having an attorney will probably advance this process. In terms, I know it's always unfortunate when everybody has to go out and get attorneys and all that good stuff, but sometimes it is very helpful because they can understand and help you filter and understand what's going on, what you're being alleged of doing, or what you are being accused of doing, and how to address it both legally and practically. Um, but the original TRO that I entered was not, as I mentioned in that order, was not intended to be an ex parte TRO. And Mr. Hendrick provided me with a good deal of documentation that we put into the order, demonstrating that he had really done everything in his power to try and make sure that all the parties were aware of that hearing. And so the purpose of today's hearing, as is by law, when I enter a temporary restraining order at ex parte, it is the court's obligation to revisit that within 30 days and make sure that it's still necessary, or that the parties have an opportunity to come forth and give me different information or tell me that that TRO is not necessary anymore. And then, as Mr. Hendrick has requested, I can enter it permanently for the life of the litigation, or I can extend it temporarily, and that's what I'm going to do today. Specifically because I think that the general parameters of the TRO that I previously entered are acceptable. They're not overly restrictive, minus the paragraph that we've already discussed, which would allow you, Ms. Rooks, to your express concern. It would allow you to continue to operate in the feminine hygiene space, but it would still continue to restrict you, as you have been restricted for the last 30 days, from marketing, creating, selling, designing, all those things, products that look that copy the trade dress and trademark matters associated with Miss Nicole's company. Now, as I noted at the beginning of the hearing, given Ms. Rooks' intention to retain counsel, given the fact that Ms. Rooks' deadline to answer and Naomi Organic's deadline to answer, none of those have yet accrued. And so what my intention is to enter a second temporary restraining order that gets us through that deadline. And at that point, Ms. Rooks will have an opportunity to retain counsel. She will have filed an answer. We'll know if Naomi Organics is going to appear and file an answer. And we'll have a lot more information. And Mr. Hendrick, perhaps you'll have had an opportunity to talk with Ms. Rooks' attorney and figure out what y'all can agree to. Any concerns, questions, et cetera, about that approach, Mr. Hendrick?
No, not with the approach. I guess my question would be, I understand that it won't be for the duration, dependency of the lawsuit, and I understand completely the reasons, and that's fine from our standpoint. What changes, if any, would be made to the provisions that were in the original TRO that the court entered with respect to Ms. Rooks and Naomi Organics?
Yeah, my intention was only to review what I had entered previously. I'm going to take out some of the information about notice and just note, just the procedural stuff, that Ms. Rooks was here, that she's not represented by counsel, that sort of stuff. But in terms of the substantive restriction, it was my intention to leave in place all of the restrictions except the one paragraph that had been discussed that you had consented to remove relative to Mr. Wilson. And it sounds like there was some initial discussion about maybe consenting to remove that provision with Ms. Rooks. I don't know. That's how Ms. Rooks characterized it. And even you said there'd been some discussions about maybe a consent agreement, but then it sort of fell apart when you were looking at the website yesterday at 3:00. So I understand that concern. And I think to me, the real issue here is for Ms. Rooks to understand that although it can be done, it should not be done. Like just because it is easy to do and others might be doing it, what the court's order will say is that Ms. Rooks is prohibited from, marketing or placing into the space these, ads and products that, that are clearly, at least to my eye, and initially without other evidence, they seem to be strikingly similar enough to give the court concerns about trade and trade dress and other issues.
And Your Honor, the one thing that I would ask, since you're going to be reworking a little bit of that subparagraph C, is incorporating in there language that would cover her working for other companies. It sounds like she is responsible for a lot of the marketing and advertising for a company that she claims that she does not own. But she is the person who, based on my conversation with her yesterday and what she said today, it sounds like she's the person responsible for a lot of this product design and everything. So just something that would cover that, so that just because she doesn't own the company, it would still prevent her from creating ads, creating slogans and marketing for another company that would violate my client's trade dress.
So as I'm looking at paragraph 4, the second paragraph 4, I should probably fix that, of my original order, it says that Ms. Rooks is prohibited from continuing to infringe directly or indirectly, personally, or through a business entity, related business entity, or trade name. And I think that is, and that's the language of most of those paragraphs. I think it's broad enough to cover a company that she works for but does not own, because it would still be her directly or indirectly through a business entity infringing under the order.
Thank you, Your Honor.
Okay. Ms. One, I want to hang on. Let me make sure. So I entered that order on September 15th. By my math, again, I can't give anybody legal advice, but the order for service by publication was entered on the 12th of September. And it looks like the, yeah, that the acknowledgement of service on the Secretary of State was on the 7th of October, which means if I were to put this hearing, today is the 10th, if I were to put this hearing in November, say the 14th or 17th, it'd be a little over 30 days for the pendency of the TRO, but it would get us to a date past which we would know if Ms. Rooks was going to answer, if Naomi Organics was going to answer, what their status would be in the case procedurally. And if they had lawyers, then we could either, y'all could consent to something, or we could agree to a permanent restraining order of some sort if it was appropriate at that time. What are your thoughts, Mr. Hendricks? Mr. Hendrick?
Would that sounds fine with me. I was just going to ask, if we're looking at calendars, if it would be possible maybe the week after, on like the 21st. It seems like Fridays seem to work for the court. If the 21st, November the 21st might work.
Yeah, that's fine. I mean, that works for me. I don't have a problem. My main issue is, generally speaking, I want to make sure that a TRO doesn't go on unnecessarily long, when it's not a permanent injunction for the pendency of the case. But I don't have any problem with pushing it later. Again, we'll have a clearer understanding of what everybody's posture is in the case, and that will give you all a good bit of time to work out anything with Ms. Rooks' attorney.
Yes.
Okay. Ms. Rooks, do you understand? I understand you might disagree with, but do you understand what I've just laid out? And do you have any questions, just to make sure you understand it, so that when you go and communicate to your attorney, you'll know what to say?
I currently don't have any questions. I understand.
Okay, thank you. So what I will do then after we get off the call is, as I said, I will adjust the order that I have entered previously to exclude that more general language that generally prohibits her from working in that space. and then I will continue the remainder of these the limitations in place. And then the last thing I'll say, Ms. Rooks, just because again, I cannot give you legal advice, but I do want to caution you. It sounds like you understand and that you've had some positive conversations, but I do want to caution you that this is an order of the court, and that if the court were to later be provided evidence that you had violated that order, Mr. Hendrick could ask me to hold you in contempt, and there are lots of things that could flow from that are not good for you. And so I just want to make sure that you understand legally the obligation, even if you disagree with it, to comply with the order until you have a chance to retain counsel and maybe work out a different agreement. Do you understand that, Ms. Rooks?
I 100% understand. The only question I guess that I would have then is, uh, because, I wanted to be like, I'm okay with showing, Mr. Hendricks maybe some of the ads that are being run. Clearly the updates have been made to the website. Like, I just want to have an open, clear communication because I don't want to violate anything unknowingly. Because
Sure.
sometimes I think this can come down to a matter of opinion. Like, my website's purple, hers is blue, but it says some of this language is common language in the feminine hygiene field. Like, some things I just can't not say, So
Right.
there's just that gray line to me, or a blurred line of where does it become just a difference of opinion when he says I can't use certain slogans. Some of these slogans are, I'm not going to rip off anything from her, but I don't want to unknowingly violate something because I created an ad that said a word that they didn't necessarily like, if that makes sense.
I understand. And I would not suggest to you, Ms. Hendrick, excuse me, Ms. Rooks, that Mr. Hendrick is somehow allowed to direct your business operations, because that's not the
Okay.
situation here.
Just making sure.
But right, but an open line of communication. First of all, again, I think everybody on this call would suggest to you that you need to get a lawyer who can help you navigate all of those issues.
Yeah.
But certainly an open line of communication, I think will address the issue. And again, I'm not saying that I would find you in contempt. Don't have any
Okay.
evidence in front of me. I'm just making sure that you understand that the parties are obligated to comply with a court order unless and until that court order is vacated,
Yes.
even when they disagree with it or think that it was wrongly decided. And so I just want to make sure everybody is clear on that. And I will endeavor to get that order signed and filed today. Ms. Rooks, do you have, well, I don't actually need Ms. Rooks's email address. Mr. Hendrick, have you been in touch with Ms. Rooks
Yes, Your Honor.
by
I have
email?
her
And
email address.
okay.
I will represent to the court that I will serve her with a copy of the order once it's
Okay.
been issued by email.
And yeah, and Ms. Rooks, if we have an email address, then we can make sure that you get served with it for out of the system. But otherwise, Mr. Hendrick will make sure that you are provided with a copy of the order so that you'll know what the order is that the court is entering. Okay.
Okay.
Your Honor, can I please speak for a minute? Because I felt like Ms. Rooks was able to say what she said, and I was not able to say what I had to say about the conversation that she said that we had. I just wanted to say that the conversation that she said that we had was not how that went at all. When she said that, all I said was she had to change a bear. She told me that she was a part of Divine Kitty, and she asked me what was particularly I guess that she copied off of. And I said one of the things was the bear. I said one of the things was the bear, but that is not all that website has on there. When you first go to the website,
Ms. Nicole, forgive me for interrupting you, but I absolutely understand the human desire to refute things that you believe have been mischaracterized to me. But the reason that I've not heard from you or asked you or called upon you to refute what Ms. Rooks has said is that you have a lawyer. And I think importantly, your lawyer on your behalf made a decision that that wasn't necessarily a dispute that needed to be gotten into right now. And so while I absolutely understand that you want to vindicate yourself and say that's not what happened, it's not It's not necessary to the outcome of today's hearing. And generally speaking, Ms. Nicole, for the same reasons that I just told Ms. Rooks, she should not represent herself. It's a bad idea. If you have a lawyer, which you do, a quite capable one, you should let them speak on your behalf when we're in court, unless it's time for you to testify. And so I apologize for cutting you off. I understand your frustration. But that'll be what that conversation might have been. If and when I need to hear about it, will be for a different day. Do you understand, Ms. Nicole?
Yes, I understand. The only reason why I had said that was because you said that it sounds like you and Miss Nicole had a positive conversation, and so that's the reason why I said
No,
that.
That's fair enough, Ms. Nicole. And by positive, I simply meant that y'all had an actual conversation about the conduct of business, as opposed to some very not positive conversations that I've heard about in the past in other disputes. So, but thank you, Ms. Nicole. And again, I apologize if I cut you off, but thank you for understanding. Anything else from anybody? Mr. Rook, Mr. Hendrick?
No, Your Honor. Thank you very much.
Okay. This matter is adjourned. I will get that order on file for you as soon as I can. Thank you.